Well, thanks for joining us for another episode of DCCares. And this particular series, we've been talking about some just practical advice for people who are caretakers of loved ones who have some form of dementia going on. And what we want to do in this episode is talk about legal and financial considerations. And to help me with that, I have two guests. I have Steve Gish, who is an attorney. Steve, are you still an active attorney, retired attorney, semi-retired?
I like to say semi-retired, but unfortunately it's more active than that.
Okay. And you have a lot of years of experience in estate planning as well as adoption, right?
Correct.
Yeah. And then also Cheryl Easterling. And Cheryl is a financial advisor with Edward Jones, correct?
Correct.
And you and your husband also lead Gateway Church here in Sequim. Great to have you here.
Thank you.
And Steve, maybe I'll start with you. Let's say that someone has just gotten the diagnosis that their loved one, maybe a spouse, maybe a parent, is beginning that journey with some form of dementia. And they're thinking, what do I need to do legally to be sure that we are ready for this journey? What are the things that they should be thinking about?
Well, I think the first thing is to make sure that they have granted authority to someone to take care of them when they no longer can grant that authority. And we're talking usually it's a general durable power of attorney for property issues and health care issues. And it's important to get that in place, prior to them losing the ability to appoint someone. And so what that requires is them signing a document and someone notarizing their signature, and the notary needs to be convinced that the person actually knows what they're doing and who they're talking about and where they are and those types of things. The level of competence required for a power of attorney actually is not real high, and it can be intermittent. As long as at the time the person signs, they know who they are and what they're doing, that's fine, even though maybe yesterday they didn't or tomorrow they won't. So that's a little bit unusual, but it's real important to have that in place. Otherwise, if that is not in place, there may be the need to file a guardianship, which is very top-heavy, expensive. It's a court action, to be avoided.
So I guess that was my question is, if someone is watching this and maybe they are farther down the road and their loved one really isn't in a place where they could competently sign a document like that, you're saying then the next step would be that guardianship route.
Yeah, and before we started this, I told you I would talk about legal and then practical.
Mm-hmm.
It all depends who you run into as far as being able to do things. Some entities are going to require certain documents, and frankly, some won't. I mean, if you've got a friendly doctor and you walk in and say, "Hi, my wife would blah, blah, blah," and they'll just help you out. It even could be any other, a financial institution, whatever, kind of a small town, people know each other. So there's legal and there's practical.
Okay.
So the practical part could work even if the legal isn't exactly in place.
Okay.
So what I'm talking about really applies more when you're going to need all of the T's crossed and the I's dotted.
Okay. So the power of attorney,
Yep.
That's real important. Anything else that people should be thinking about legally?
Yes. If the elderly person we're talking about owns property in their own name, well, at some point it's going to need to be transferred out of their name. And there's ways to do that. First, everybody thinks of a will. You have a will and you name who's going to get your property. But then that requires a probate. So there's other ways of doing that. And I usually pick on the guys because we go first. Usually the widows are in town and the guys are gone. So in my office, we talk about what's called a community property agreement, which is a one-page document that basically converts everything to community property, which it probably already is anyway. And then it simply says on the first to die, that person's share or that person's interest transfers to the survivor. So then that survivor, usually the wife, now owns the property in her own name. All she needs is the death certificate and the community property agreement, and she could transfer title to anything into her own name. Okay. So that's one document. Some people, and this might get a little bit longer, some people think, well, we'll just have everything signed to our kids right now. We'll just keep living in the house because they'll let us. Several problems with that. One is the creditors of the children, and when I say children, we're probably talking people in their 50s. The creditors of those children have access to the house. And the other problem is they take the property with the parents' basis, which, very simple example, in Sequim, you bought a house 35, 40 years ago for $50,000. That's your basis. That house today is worth $500,000. So if the kids receive the property prior to your death, they take your basis, which is $50,000. Then they inherit it after you die. They go to sell it for the current market of $450,000. They now have a $400,000 gain to pay taxes on. So huge benefit to not transfer the property to the children until after you pass. And another simple document to accomplish this, it's called a transfer on death deed, which is just what it says. You sign it now, it gets filed now, but it doesn't do anything until you pass. The kids get the property automatically, no probate, no lawyers, and it's revocable in case you change your mind. So those are a couple of things. Another one is similar at your bank. Have all your accounts be payable on death. So upon the death, it's just what it says, it's paid to the children. Again, don't make them co-owners of the account now, as in a joint tenancy with right of survivorship, because that means the kids' creditors also have access to the account.
Okay, and I think that's key, because sometimes people go, well, I trust my kids. I know they wouldn't do anything irresponsible with my money. But what I hear you saying is, well, yeah, but there's this other player potentially, these creditors, that if your kids maybe got unemployed or something else happened adversely and a creditor comes looking for money, suddenly those creditors have access to all of your assets.
That's your kid's asset just as much as yours. And yes, and I've seen a lot of negative stories. Things go wrong in people's lives. Let's just put it that way.
Yeah. Okay. Well, good stuff. Cheryl, let's talk about the financial piece of this. I mean, a lot of things Steve has talked about are kind of looking at the end of life, being prepared. Of course, power of attorney, real important. But there's all this financial stuff currently, day-to-day living. What are some things that you would suggest a caregiver be paying attention to financially?
Well, when you have a loved one you're in the beginning stages of dealing with dementia, there's a huge change that happens in how we live our lives. We go from operating at one level of stress, and then before you realize it, you're operating at a very high level of stress. So it's very important to lower your stress level. And financial stress, sometimes we don't realize the amount of stress that happens because we think it's normal. But what happens whenever you are caregiving, you have to think about where is all the money. And for a lot of people, a lot of spouses, there's normally one spouse who takes care of the finances, who's in charge. And oftentimes it's the spouse that has the dementia. And the other spouse who left it up to the primary spouse to deal with the financial things, you can be kind of left in the dark. So it's very important to, at the front end, at the beginning, find out what you own and where it's at. Many people have investment accounts all over the country with advisors or just with companies that they've had for a long time. They get the statements and it just seems normal and natural. But when you're under stress, knowing where is that company, where's the phone number, who do I call, how do I contact them, who am I going to speak to, am I going to understand these processes, and then what will be the process for accessing this account if it's in my spouse's name? How will I get that power of attorney active on that account? What will that look like? What will happen if my partner passes? How will I process that? So all of those thoughts in the back of your mind will affect your daily living. Number one, you might need that money to pay for ongoing expenses. You're not quite sure what those expenses are going to be. So having access to the money, knowing where it's at, knowing how to get that money if you need it, and knowing what the process will be to add a power of attorney. And adding a power of attorney can be complicated when you're talking with someone on a toll-free number several states away and working through the mail. Sometimes there's faxing, sometimes there's secure documents. Every company has individual processes. You had a really good point about, there's the legal part, then there's the practical part. Well, when you are dealing with someone on a toll-free line, it can be very particular. I've processed things that are out of country, out of state, and it can be quite difficult. So a good thing to know is to gather all of the insurance policies, investment accounts, any type of holdings that you have, gather them and go through them, see where they're at, contact information, and then consider consolidating those accounts into one place with one advisor as much as you can. That will take that financial stress down several notches because you'll have someone local. If it's someone that you trust and you have a relationship with, you can work with an individual person who can help with all of the processing, the phone numbers, the handling, even putting power of attorneys on accounts or just moving the accounts somewhere local. That can take the stress down several notches. The Hutchinson Institute for Cancer Outcomes has done extensive study on financial toxicity and how financial stress affects our health. And they've documented that the stress levels are they make people sick, and so it's a known thing, and it's something that can be avoided if you're in front and you're thinking ahead. What can I do now to help later, and being proactive. And then a good financial planner can help you budget the money and have a good solid plan in place to make sure that the money is doing what it's supposed to be doing, earning, growing, meeting your needs. A lot of times with people with investment accounts is I will see people who have a financial plan that's really outdated. It would have been great 10, 15 years ago for where a family's at in their stage of life, but it's not quite current with today's needs. And when we deal with a long-term care situation, we need more liquidity, so we'll have more money free to spend for the expenses.
Okay. Well, good stuff. And I realize this is not a marketing piece by any means, but I would say, and having worked with a number of families as they've been going through the journey of different kinds of illnesses, I think it really is worth sitting down with a good attorney, sitting down with a financial planner, and just talking some of these things through for your particular situation. Again, having someone local that you can work with means a lot. And I think it's a great point of consolidating accounts, simplify things for yourself, and then as much as possible, make sure that you've got the power of attorney in place and you've got wills and other things updated. It's just that, like you said, that one big stress piece that we can help take out of the equation because there are going to be plenty of other things to deal with besides the legal and financial stuff. So, Steve?
Sure. So a couple things, as you were talking, made me think. I didn't talk about trusts at all. A lot of people think, or maybe even have trusts. I've had people come in with notebooks that they bought a program somewhere, and they don't know anything about what the notebook even contains. So it's good to know exactly what you have. And if you have a trust, people think, well, I'm done. It's automatic, and I'm protected and everything, which is not the case. First of all, a lot of people don't even fund the trust, meaning you have to transfer all of your assets into the trust. Think of a trust as a box, and you've got your house. And if you put your house in the trust, you don't personally own the house anymore. You've deeded it to the trust, the Tim Richards Trust. That now the trust owns the box, or owns the house. A lot of people don't even do that, but you have to do that with everything, all of your assets. If it's a means to try to avoid probate, you got to own nothing. The bumper sticker that says, he who dies with the most toys wins is exactly backwards. The idea is to not have anything. That's why I talked about the transfer on death deed and like that. But if you have access to what's in the trust, your creditors have access to it. So people think, I put it in a trust so it's safe. Well, that's not true. Another thing is dealing with some negative things that happen. I always ask people, well, is there anybody that's going to cause a problem in the family? And I would say about half the time someone says, yeah, we've got this brother, long lost brother, he's an alcoholic, he's out of state, but he's going to maybe cause a problem. So one strategy is when you do a will, have the person's doctor be a witness. There'll be no claim then that the person was not competent.
Okay.
Because that's just maybe a little negative, but it's kind of practical.
Right.
Just a couple things to mention.
Good. Well, thank you both for taking a few minutes to talk. I know there's lots more we could talk about with this stuff, but I think it gives people some good starting points. And I hope it's been helpful to all of you. And that'll wrap us up, I think, for this episode. And we'll see you on the next one.